So the headline in the Capitol Journal says that the justices are skeptical over this solution that the legislature has come up with. What are your thoughts on that?
Well, I think everyone expects them to be skeptical. There's been a lot of stuff already put out in the press about the impact of the hold harmless provision and whether or not this really is just moving funds around or if it's putting money in to solve the problem. So it doesn't surprise me that people would interpret their questioning as indicating skepticism.
Well, there's a history, too, since the Montoy case of the court making certain findings about constitutional funding for schools, whether it's adequacy or equity, and the court being told by the legislature they were going to fix it, and then those fixes seem fairly temporary. Now we have yet another fix, quote unquote, that may or may not be a fix. I think it's human nature, and especially in light of the court's experience with the legislature, that they would be skeptical about what the legislature proposes as a, quote, fix for the equity issue.
Well, and a lot was made yesterday over some of the comments that the justices made during the testimony. Did you hear anything that stood out, or anything that we should keep a closer ear on?
Well, not any one comment, but the notion that on the one hand, the plaintiffs seem to want to throw the entire block grant piece out and go back to the funding formula that existed before with an equity improvement. That's a fairly broad brush remedy. The remedy that the state proposes is, well, what we've done is a, quote, good faith effort. And there's a lot of distance between substantial or good faith effort to follow the court's order and the plaintiff's position on throw the baby out and go back to where we were before. It's not so much a particular question, it is the breadth of difference between remedy suggestions from the plaintiff and the defendant that caused me some concern. So
it sounds like you think there might be a lack of willingness to really just kind of start over from scratch, basically.
Well, look, the court's not this is not a trial court. This is a court of appeal. So they're not there to weigh facts and so forth. They're there to appeal a lower court's decision. And in this case, they're asked to apply a formula approach to a lower court decision. Our courts on appeal are sort of limited to, they don't want to give an order broader than necessary. I mean, if you ask them what's 2 and 2, they're not likely to give you a history lesson on mathematics. They'll say it's 4. So they try to limit their decisions to the narrowest possible language.
And I would go back to something David said too about the plaintiffs wanting to just go back to the old formula and fund it. That there are 2 positions here, one of which has been that the old formula actually was a good formula if you funded it appropriately, which I think is where the plaintiffs are for the most part, and the state via the legislature and such are of the opinion that the old formula is horribly flawed and can't work at all, which is why they threw it out in favor of the block grant. Those are extremely and the block grant being temporary as determined by the legislature. They said up front, this is just to fill the gap while we write something new. In other words, they don't believe in the block grant necessarily. They believe in something has to be done. So you've got these 2 hugely different positions. One being, we had a good formula that addressed the needs of schools, that had equity, but was never funded properly, and in the last few years has been monkeyed with to the point that it destroyed equity within it. And another side saying, we have no clue what it is, but it's got to be radically different. and the inability to define what it is the state wants is an issue.
Well, the word I'd use to describe the plaintiff's position is that the old formula was structurally sound,
Right.
but that the lack of funding applied to the formula created inequities, and they, I believe, would go farther and argue that there's basically a large adequacy problem as well, and that's an issue which has not yet been addressed by the Supreme Court, the adequacy piece, that is.
Well, and Mark, without getting too far off the rails and in the weeds here, you mentioned something new, and with the new formula that's been proposed by Senator Abrams and Representative Hyland, isn't that a preview of something new, and doesn't that make it more difficult to deal with this equity issue?
Well, I think what Senator Abrams and Representative Hyland put out is their vision for public education, which is essentially to dismantle public education in favor of vouchers and private schools and tuition tax credits and all kinds of extremist ideas. I think it's a preview of what at least a camp in the legislature would love to do. I think that is the goal of the extreme right wing of the Republican Party, is to simply do away with public education as we know it entirely and privatize the whole system. I think that's where the Abrams bill, the Hyland bill, would take us. That's not to say there aren't other camps within the legislature. There certainly are. There are other Republicans who would never support what's in that bill. There are Democrats who would never support it. And so I think there are probably 5 or 6 different visions for what a new formula would look like, one of which is the Abrams-Hyland formula, one of which is the return to the old formula and fund it, and probably a lot in between.
Could that preview kind of steer this court in any way?
I don't know that. I don't think I subscribe to that. What I would say, though, is that the Supreme Court, like every other court, is not unaware of the politics that surround this entire funding issue. 5 of the justices this year are up for retention. There will be an election in November to see whether 5 of those justices are returned to office. And there are a lot of moving pieces in this discussion. The equity issue, the Hyland proposal, the politics of a general election for the Senate and the House, and the Supreme Court retention issue. So I think there are so many moving pieces, it's pretty hard to be clairvoyant and accurately predict the outcome of much of any of that.
And I would add to that the beauty of our Kansas Supreme Court is that by having a merit selection process for the selection of justices to the Supreme Court ensures that our court is really engaged in protecting the Constitution, in giving. They're not going to be swayed by politics under our current system, because they're not political appointees. They have been chosen for their merit, for the work they've done in the past, for their ability to be fair and impartial and objective and uphold the Constitution over political whim. And I think that's very important to remember. Now, we are attempting to turn the court, some in the legislature and the governor in particular, into a political system such that they will bend to the will of the governor or the legislature or the political whim of the moment. And that's what this retention election is probably going to be about. It's about people that want to throw them out because they will not bend to one side or the other, that they are listening objectively and impartially and fairly to both sides of the argument.
So this transitions right into my next question. Has this funding case kind of morphed into a battle over the separation of powers?
I think it's one of the issues which has politicized the judiciary's role, and I think it would be unrealistic to discount that change. There are a lot of people in the legislature who have a strong interest in a more singular branch of government than we currently have. More and more power concentrated in fewer and fewer hands in the governor's office and or the legislature. So I think it's anybody who's paying attention to what's going on or has been going on for the last couple of years has seen a trend towards trying to make more political hay out of judicial decisions, whether it's this case or others.
The dark cloud that kind of hangs over this case is this impending threat to not fund schools and then essentially have them closed, which was a court ruling previously. Legislators like Ty Masterson have tried to pin the blame for that threat on the court, but isn't the blame more rightly pointed on the legislature and its inability to do its job here?
I think absolutely the blame for whatever happens lays with the legislature. Again, the courts, the role of the court is to hear challenges. The court has heard this challenge through Montoy, now through Gannon. They have ruled, it's been appealed, they've gone through the appropriate legal procedures to get where they are today. Exactly how our system is supposed to work. In any court decisions, there's a winner and a loser. You have the right to appeal. You move on. You try and get to a final decision, and the Supreme Court is the decision maker ultimately to where we go. So I want to point out that the court is doing what the court is supposed to do. And there are those who want to pin the blame on the court, but the court isn't shutting the schools. The failure of the legislature to meet their constitutional obligation to the schools, to the children of Kansas, that's what ultimately will decide whether the schools open or close. I suppose the court can say, well, they've made a good faith effort, we're going to let it be open, or the court can say you've not done nearly what you need to do, they're going to close. But it's not the court who's making that decision. It's been a political decision all along. It's politicians deciding how little can we do to just keep the door open, not can we do what is right, can we do what we are obligated to do under the Kansas Constitution. And I would point out that the Constitution doesn't talk about a minimal education. It talks about to providing for the improvement of, and I forget how the wording is exactly, it's improvement of vocational and educational and other needs of the state. That's what's really at issue. It's not the court who's going to shut it down. It is the inflexibility
it's the result
of the legislature, and it's the result of the legislature not meeting their constitutional.
It's an example of trying to blame the messenger, essentially. The messenger might be the court making its decision, but the message was created by the failure of the legislature to adequately and or equitably fund the system. Let me add, though, curiously enough, there are three of the justices over there who have pretty deep understanding of how schools operate. The chief was an attorney for the Salina School District for many years. He knows how schools fund and how schools operate, are funded and how they operate. Dan Biles, Justice Biles, was the State Board of Education's attorney for many years. He's very knowledgeable about school funding, how schools operate. Justice Lukert, the same. She was a district court judge, has deep experience in how schools operate. So it's, if you'll note, those three, certainly Biles and Lukert, were offering some of the most challenging questions yesterday in the arguments. They they come to the argument, they come to the court with more understanding of those educational funding and operational issues than you would expect a typical justice to have. So I think it bodes well for an informed, well-written, well-reasoned opinion. I don't think anybody's making bet on what the outcome will be, but I think it will be a well-reasoned opinion, whatever it is.
So let's make that bet now. If the skepticism kind of plays out in a ruling against the state, and the inequity continues to exist, where do we go from here? And when I say that, I'm not asking for necessarily an opinion on what the solution is. I'm asking what the mechanics of a process would be to solve this issue before schools hopefully open in the fall. Is there a special session that would have to occur? Would the court take some other action? What are the mechanics of this?
Well, I think there's, from the legislative side of things, and your question is assuming the court says what they have done does not meet the requirement. Mm-hmm. So let's say that that's their ruling, and I don't think we can say with certainty that it is. I mean, we can all speculate, but let's say that's their ruling. The legislature, depending on when that ruling is made, if it's made before June 1st, which is when sine die is scheduled, the legislature has the opportunity to go back into session, not a special session. They have days left since they ended early this year. They could go in and craft a new bill to attempt to fix the issue before sine die. They also have the opportunity to, as I understand it, to pass a new motion to push sine die back to give themselves some time to do that. Bottom line is, according to the court, at least the earlier decisions, they have to do that by June the 30th.
Let me stop you there for a second and ask this question. If they did that and they had to craft a new bill, is that bill kind of fair game and open for all kinds of politicized policy that could be put into it, or is it strictly focused on this issue?
I think they could probably do pretty much whatever they wanted with it and could get 63 and 21 votes to do. Right. So there's no limit on what they can or cannot do in a session, and if it were still the regular session, that's certainly true, and we believe after that looking at the rules for a special session is likely to be very true in a special session as well.
Well, it seems to me, though, the real value of anyone watching the presentation today is, let's don't make an assumption about what the court's going to do. We're hopeful the court will make a decision promptly, giving the legislature a chance, if necessary, to fix whatever frailties there might be in the current equity piece. I'm optimistic that schools will open. I'm optimistic they'll open without regard to whether the court finds the equity piece to have been satisfied or not. I mean, the court does have other options. The court could make some limited change in the funding piece, could allow schools to open, could extend the deadline beyond July 1st. There are lots of options there, and we can speculate about what they are, but they'd be just that. They'd be speculation. I think the thing to focus on is where do we go from here without regard to the court's decision. There are a lot of decisions to be made by the general public in the next 60 or 80 to 90 days, and 120 days actually. But
so let's finish with that. Regardless of how the court rules, we have a period of election going on here, a campaign season. What should our members do? Would just general public do during this summer and in the coming fall? How do we keep connected to this and move things forward?
Well, obviously you have to keep reading and keep reading, whether it's Under the Dome or your local newspaper or listening to your radio, to understand what's going on, to keep an ear open and keep an eye on the press so that you know what's going on and you know what's potentially going to happen. The second thing is to start now going to those legislators back home and demanding that they do right by the children of Kansas. That the greatest economic development tool Kansas has is an excellent school system that produces a workforce that attracts businesses to it. We're not going to bring people in for our beach resorts or our mountain paths. We're going to bring people in here based on the quality of life and the quality of the workforce. And we need to make that very, very, very clear to every one of these people who are running for re-election this year, that that's got to be paramount. People have to get registered to vote. They have to get into the political and legislative process and hold these legislators accountable. Even if this is accepted by the court as a solution to the equity issue, we're not done. We've got to get through the adequacy issue
Correct.
in the next year.
Right.
And that's going to be far more difficult to get through than the equity piece is at this point. We need legislators who will look at schools and children as the future of this state and the economic development engine that they truly are.
So if I'm that teacher who just says, I'm going to close my door and keep my head down until this blows over, or I'm that brand new teacher to the profession who is focused on making it through tomorrow, what do you say to me as far as why I should really get involved in this? I know you just gave some good points there, but what brings that person out of their kind of bunker mentality to really get engaged? How does this really impact them in the future?
If you're a second grade teacher and you have 30 kids in your classroom and no assistance, if you haven't gotten a raise in 3 years, if your health insurance plan continues to cost you more money and there is no more money available to the schools, and there are some real world practical negatives that come with a poorly funded school system. Greater responsibilities, longer work hours, less pay when adjusted for inflation. I mean, there's a real world application of bad policy making to the classroom, and people who are in the classroom doing that challenging work need to, in my view, sit up and say, wait a minute, if I don't do anything, I become part of the problem. And I think there is an opportunity, a really genuine opportunity, to make some changes in who makes decisions on public policy in the legislature. This is the time to act, not next January fret about why there was such a poor outcome in November.
And I would say it is the teachers' working conditions and whether or not they have a fair wage and so on. That is important to this. But what's also important to that first-year teacher who's just trying to get through, or even to the veteran teacher who just as soon lock themselves in a room and concentrate on it. How do you concentrate on it when your textbooks haven't been replaced, when you're using outdated textbooks, when you can't get your technology upgraded, when your class size gets bigger every year?
When there's no training to use that technology.
When you don't have any professional development opportunities, where you're losing counselors and school nurses and the support people in your buildings that make it easier for you to teach, that make it easier for you to reach each and every child effectively every day. All of those things are at risk in underfunding our schools.
Well, if the LOB is affected by the court's decision, if they make some decision about the LOB, many school districts rely on the LOB for a significant portion of their funding. So let's say schools do open.
Hang on one second. I'm a first-year teacher. I don't know what an LOB is.
It's the local option budget, which funds anywhere from 20 to 30% of many school districts' budgets. Their general fund budget, out of which classroom and expenses and salaries are paid. If the school's open and that money's not available because it's inequitable, it is inequitable as it's applied across the state, that has a direct impact on things like who sweeps the floor in your room, who cleans your chalkboard, who drives the school bus, who prepares the food in the cafeteria. All of those pieces that nobody. Or what about the exceptional child? What about a 504 plan or some other mandated federal project that there won't be any money for? I mean, everybody who's in education has a stake in a positive outcome, not only in this election, in this court case, but also in the election coming up in August and then again in November.
Is there anything we've left out of this conversation?
I think you pretty much touched on it. Again, I think we need to focus on the fact that whatever the response is, it's a response based on the Constitution of the state of Kansas that was crafted by and approved by the people of Kansas. This is not a political issue. This is a constitutional issue. I think we need to keep that in mind. And we also need to remember that regardless of the outcome here, there's still another case, which is the adequacy case, to be finished down the road, possibly by the next legislative session. So whatever happens this month, it's not over.
I've got one last thing that I just thought of as you were talking. For the member out there of Kansas NEA, when the ruling occurs or whatever happens, what's their first point of contact other than watching these videos and Under the Dome? If they have questions, if they have needs or concerns, what's their first point of contact?
We can give you Mark's cell phone number if that'll be helpful.
Yeah, but Baltzell doesn't answer that all the time, and neither does Mark Farr. I think your first point of contact for a KNEA member is KNEA. Download the phone app. Get on to Under the Dome. Get into the Join Us campaign so that you're getting that information. You've got all of that at access. You've also got your regional offices and your local officers who get a lot of information from KNEA and hopefully are up on these talking points, what's going on, and following it closely. So your local president, your regional officers, your UNISERV district people, your UNISERV director, and ultimately KNEA itself via the mobile app, Under the Dome, which is online or via email, and the Join Us campaign for any breaking text alerts.
That's it. All right. Thank you, gentlemen. We appreciate it.